Hi, my name is Andy Nelson. Today I am going to talk about intellectual property basics. Now, if you don't know what intellectual property means, let alone the basics, don't worry, I'll get into that in just a moment. The fact is I've been doing legal work in the intellectual property field for 20 years now. It's 2022 right now. So just over 20 years. I've been helping businesses figure out exactly what their intellectual property might be, help them protect it, help them defend it, enforce it, and related business matters. So I have a lot of experience in a variety of industries helping businesses or aspiring business owners identify and put fences around their intellectual property. Now, what are we going to do today? I've got two purposes. One, I'm going to give you this overview of what the main types of intellectual property are, or IP. I'll use that term quite a bit. You've probably heard both before. And then talk about what each one of those main types protects. And then second, I will share some best practices about not only protecting your IP, but also avoiding problems, right? There's one thing to protect your own intellectual property, but you don't want to at the same time, or ever, if you can avoid it, encroach on someone else's, because that may lead to some disastrous results. Worst case scenario, a lawsuit, quite a liability exposure, and best case scenario, just cease and desist letters, and just the headache of dealing with something like that. Okay, now I told you I was going to talk about intellectual property, but let's kind of back up and talk about just property in general. You're probably familiar with some of the conventional types, the ones that are intuitive to us. One being real property, right? We've heard of real property, meaning things like land, right? Raw land, but offices as well, businesses, warehouses, those sorts of things. Even leases themselves is a type of real property because it's an interest in real property. We understand what that is. We also know how to protect it, right? You lock the office, you close the gate, you roll down the door, whatever. You understand how to protect real property. It makes a lot of sense. And you understand kind of what its value is and what it does for you. Personal property. That's kind of everything else, right? Anything from the camera that I'm looking at right now, to this pen right here, to the jacket I'm wearing. It's just tangible stuff, right? Tangible stuff that's not land or attached to land is kind of your personal property. And again, you know how to keep it safe, you hold it, right? You lock it away, put it in a drawer, put it in a safe, whatever. It's inside a home, it's inside an office, it's all this stuff in there. You know how to protect it. But then there's this third category that sometimes we probably don't really think about or identify or consider as property, even though the word is right in the title, intellectual property. And what that refers to is really this kind of category of intangibles, intangible things that over the course of the past number of decades and even the past number of centuries, Western law and now law around the world has really treated or given properties that are like property. It's considered to be things that you can actually own and treat and alienate and that sort of thing, like conventional types of property. So, intellectual property, I just mentioned it a moment ago. It is a kind of just a generalized term for these categories of intangible properties, creations of the mind, that sort of thing. There are some outlier types, if you will, but there are really four main types that you experience probably with some regularity, and you've probably even heard of all of them. One being patents, right? Patents, what that refers to is, generally speaking, inventions, right? Your classic mousetrap, or your device that you create, or even a methodology or a system, something like that, some kind of useful invention. That's the subject of patent law. Two would be copyrights. Now, copyright, a lot of people think copyright applies to just anything you create, because you think, I create something and therefore I have a right to prevent people from copying it, so I have a copyright. Not quite right. Copyright does protect quite a few things, and these tend to be expressive works. Everything from the written word literary content all the way over to audio-visual work, but including other things like photographs, also even architectural plans. So a lot of different types of expressive works, those creations by authors. Copyright is the type of intellectual property where those items find their protection. Third are trademarks, something that every single one of you encounters every day of your life, multiple times per day. Trademarks, that law really protects the types of things, and I say things because it can be a lot of different distinctive things that identify goods or services, right? Helps you differentiate one from the other or locate a source. Names, it can be words, it can be logos, slogans, and a lot of other things. We'll talk a little bit more about that. And then finally, trade secrets. And we're probably familiar with some of the more popular ones out there. I'll talk about that a little bit later, but this trade secrets really protects what we call valuable commercial information. That is, no surprise, secret, okay? So those are the four main types. There are some others, we won't go into those today. Why are you gonna care? Well, you're gonna care because whether you think it or not, intellectual property might be your most valuable business asset, more so than that personal property and that real property, if you have any of it at all. And if not the most valuable, maybe one of the most valuable. And at the end of the day, that allows you to do things like build a following, build brand awareness, right? Why do people follow Apple, right? Because they're just so, they know that term, Apple, or its Macintosh logo, comes with it a lot of goodwill, a lot of basically unspoken promises about quality and that sort of thing, right? People really follow those sorts of things. That doesn't apply just to, I just gave you a trademark example, but let's talk about an invention, like some technology, right, that's involved with, say, Apple or Samsung. Yeah, the brand names themselves, but the technology behind it also helps build followings. Intellectual property may have its own value, this intrinsic value that allows you to do things like, license it, or maybe just, sell it itself. Somebody else wants it more than you, and if they're willing to pay for it, hey, that IP I developed, fantastic. It kind of related to what I mentioned a moment ago with building brand awareness. It can give you a competitive edge, right? Many years ago, Gore-Tex, some of us still know what that is. Not only was that a popular trademark, but it referred to the product itself, the technology, right, of a permeable, yet water-resistant, dare I say waterproof fabric that, to me, was kind of head and shoulders about everything else. Even if it really wasn't, I certainly thought it was, and it made people think it was, and it had a massive following and a huge competitive edge over other sorts of breathable fabrics that were out there. And then, intellectual property can help you really establish yourself in your own market and grow it, and maybe move into a new market. Not to stick with Apple, but I've made this reference before. If Apple decided to get into the car business tomorrow, manufacturing cars, they have so far as I know, no prior experience doing that, maybe a little bit of research and development. But if they came out with a car tomorrow, they would have quite a large prospective customer base immediately. Why? Because people are just gonna, on some level, are just gonna assume that whatever they do is going to be solid. Notwithstanding the fact they have no experience there. And that reputation they built up already and their know-how would help them leverage right into a brand new market that they haven't been in before. So IP can be a very valuable asset. And if you were to ask, what is the biggest asset of some of the most valuable companies in the world? Google, Apple, Facebook. It is not real estate, real property. It's not personal property. It's the intellectual property that's really driving up that value. Okay, let's talk about each four categories at some greater length, so you have a good understanding of kind of the characteristics of each and how to really kind of compartmentalize each one, so you can really credibly talk about this as you're kind of inventorying your own intellectual property, or even conversing with other business colleagues about what you have, what they have. It'll just make you be more aware of the value you may have in your company. Now, the patent, I mentioned earlier, it typically relates to a useful invention. Now, what is it? It is a grant. A patent is a grant of a right from the US government for a limited time to basically have a monopoly over a type of invention. That gives you, as you can see on the slide here, the right to basically exclusively exploit its value, including importing it, right? So just because you have a patent here doesn't mean that somebody gets to go develop the product in a foreign country and then bring it into the US, right? You have that real bubble, that force field around a patent, typically for 20 years with a utility patent that gives you a lot of time to exploit it sell it before it goes into the public domain and everybody else gets to use it. So it's a trade-off, but there's no such thing as just developing a patent. You may conjure up patented or patentable technology, whether it's a simple mousetrap, maybe very simple or maybe very complex, but you don't have a patent unless the government gives you a patent, decides that you have really kind of checked all the boxes and you get a patent. As you see on the slide here, I have in yellow utility patents. Utility patents are the most common type of patent. That is kind of your classic invention, the greatest thing, since sliced bread, so to speak, the mousetrap, or the process, think about a process for applying lacquer to a surface or something like that. That's your utility patent. Let's look at a few examples. Now, on the left, you're going to kind of see, your classic mechanical device. Now, if you don't recognize what this is a trigger assembly for a pistol. It happens to be an adjustable trigger. It's a patent that we got through not too long ago. That's kind of your classic, an example of a classic utility patent. I said there were other kinds. On the right, you see what's called a design patent. Now, design does not mean I design some utility patent. It's a specific kind of patent. Instead of being a functional utilitarian invention, follow me here, a design patent actually gives you an exclusive right to an ornamental feature of a product. So in this case, you have you might have guessed, it's a sheepskin boot, and you might know the brand as UGG, or the company behind it, known as Deckers. And what they have here is a design patent over the appearance, this ornamental appearance of an upper on one of their boots. So it has no function. That button is faux, at least I think it's faux, but at any rate, this is to protect an ornamental, non-functional feature, which gives them, again, quite a bit of a monopoly over that appearance for a number of years. So that could be a valuable right for them and for others who design a lot of ornamental appearances that have value. Okay, moving into trademarks. Trademarks, I mentioned the word thing earlier. I'm going to do it again. They are distinctive things that identify a single source of goods and help you as a consumer differentiate one source of goods from another. So let's illustrate it, okay? Right? We see something like this. We have trademarks of a single company that point to the same things. We got a word, we just had a logo, and we got a short slogan. So words, plural. Now, let's look at this a little bit deeper. Okay, we mentioned trademarks. They can be words, right? You understand this. Apple, for example, the logo, we just looked at the swoosh. There are plenty of logos out there. And slogans, we looked at that a moment ago, but there's others like Prudential's Get a Piece of the Rock, and it goes on and on. And then one thing I didn't show on the slide before are even personal names, right? George Foreman, Kate Spade, Ralph Lauren, Tommy Hilfiger. I mean, the list goes on. It's possible. It's not as easy for a personal name, but it is certainly possible. And is there any question about whether those names I just put out there identify a source of goods or services? You know they do, so it's possible. What else might function as a trademark? Now, I'm not sure if you're going to hear this sound.
Nationwide is on your side.
No! Okay, I just did two if you didn't hear them. One was the Nationwide is on your side jingle, right? And the word nationwide's in there, but the jingle too, right? It just conjures up an immediate visceral reaction to that source. Like, you know what it ties to. It ties to insurance services. And then Homer Simpson's dough. I mean, that can be a lot of things. So you think of it as identifying the entertainment services, but it may identify a lot of other things. What if that dough is, you hear that and you're in the plushie section of any given store, that may be a trademark for that kind of a product as well, something that identifies the source. You're not going to